One of his few failures.
Like to see what they've been trying to find throughout the ages.
Good almost afternoon, and welcome to our monthly work session dated December 12th, 2017. The first item on our agenda today is the complaint investigation process.
Yes, before you begin your conversation of this item, because of my unique history with this particular employee, I have regularly recused myself of any conversation dealing with her, and with your permission, I would like to do so this morning and allow Scott Limpy to represent our administrative team.
Hearing no objection. Thank you. Give a minute before we proceed.
Good morning.
Good morning.
For the record, I don't like the big chair. So, go ahead.
Well, and I'm actually going to have Mr. Hardy speak first as it relates to making sure that we stay specific to the topic. So, Mr. Hardy?
Okay, thank you. As the board's aware, there has been a complaint filed that implicates, at least, or potentially implicates some conduct on behalf of the superintendent, which is why he has recused himself and why the board is frankly even discussing this process at this point. It is my thought, and in conjunction with talking with the board chair and with Mr. Limpy, that it would be appropriate in this case to employ an outside investigator to look into this claim, not to put that responsibility on subordinate employees in the district. I think that would be more fair to those employees, certainly, and to have a process that is free from any claims of bias within that. So the purpose of today's conversation, and let me just say, the workshop obviously is a conversation about some of these topics. The board, if it wishes to take action, whatever action it wishes to take, it would take at the board meeting this afternoon. But this is the time to discuss the process. I would like to stress to the board my strongest advice to you on all these matters is that while it's appropriate for you to be talking about how we proceed, it would be also very appropriate for you to refrain from further comments that could in some way either really or impliedly impede the investigation. Until an investigation is completed, then obviously any such report would be delivered to the board for the board to decide what, if any, action it needs to take vis-a-vis your direct report, the superintendent, and for Mr. Limpy to decide what, if any, action to take against any subordinate employee in the district. So the purpose today is to say, I believe an outside person should be retained. I believe that is a person who should not be in any way involved with the district or previously involved with the district or any of the parties, someone who is a neutral, someone who has experience in law/HR, and that the board empower either the board chair or Mr. Limpy or both to work with me to find such a person, contract with such a person, and get him or her started on this, and then report back to you with a report.
Caroline?
I would concur with that. I'd be perfectly happy to have it's formal. I'd have Bridget work with Scott and try and find somebody that would come in and could be the mediator and to discuss this without having the superintendent involved. And with the two of you involved, that means the boards and the administration are covered.
Okay. Jane?
I think we need to have a little bit of background into why we're doing this. There may be someone who's watching that doesn't exactly know what the issue is. So would you give us some background before we make discussion. What is the issue at hand?
The issue is, and ordinarily we don't like to talk about the details of complaints, and I will try to refrain from too
Very
much.
minimally.
Very minimally. It has certainly been in the paper, so this is not a surprise. A complaint has been filed by an employee alleging that she has been retaliated against by her direct supervisor. And the allegation of retaliation is based on a previous complaint that she filed involving Dr. Bowden. So in other words, the claim in its broadest stroke is, I made a complaint about the now superintendent. As a result of that, now, at this point in time, I am being retaliated against because I took that protected action.
Did she file a complaint before?
A complaint was filed after there was an investigation done.
Correct.
Prior to the physical filing of a complaint. There was a complaint filed after the fact. So
I'm fine with the investigation going forward. We only have one employee, and that is the superintendent. So I'm very, very happy with Mr. Limpy taking the lead on this. I think, of course, Bridget being chair will be more involved, but I'm very happy with Mr. Limpy deciding on the investigation. I think we need to make sure that we do this appropriately, and administration under Mr. Limpy's guidance, I think, is appropriately able to do this. You've been in charge of human resources and other departments, both directly and indirectly, for some time, so I'm fine with that as well.
Eric.
Scott and I have discussed this, and Art and I have discussed this. And conceptually, I agree that Scott and it's got Todd's name up there, so it's a little disconcerting. That Scott and Art be the core of the investigation team, but I think it's important that you use the word empowering. I think the empowering should come through the chair and not through one of Dr. Bowden's subordinates. I think the authority should flow through the board to the chair, because I don't believe that that's going to influence the outcome of the investigation one bit, but I believe that perception is an issue that we have to deal with, and so and Scott and I have talked about this, and the perception of making sure that it's not one of Dr. Bowden's subordinates heading it up, but it's the power flowing through to I guess the other way is the delegation of authorities are flowing from the board chair to Scott rather than Dr. Bowden, one of his supervisors. So when he's working on it, he'd be working at the behest of Chair Ziegler. Will that affect the day-to-day operation of the investigation? No, it won't. It won't change anything one iota. It makes the process a little bit more cleaner, that it's crystal clear where the direction and the reporting process goes. It goes from, in this unique circumstance, Scott and Art will be, he's already for the board, but it'd be in this unique circumstances, Scott will be reporting through to the board, and because we all can't meet day to day, it would be headed up by the board chair on those incremental basis. So again, it won't change the final outcome, but it just makes it cleaner for perception.
Shirley, and then Caroline.
In that scenario, would she alone have the ability to hire the outside investigator?
If I can interject, and the reason we're having this is there's no roadmap right now that we have vis-a-vis policy. So and this is exactly why I wanted us to all weigh in. So what those parameters look like, and the board chime in as to what we'd like to see. I know what has been proposed, and what I personally thought as an individual, which is why we're having this conversation, was that it be far removed from any perception or perceived or direct conflict of interest. So I think that parameter could be set today in this discussion with an action taken at the board meeting.
What my concern would be is that an action that the board would then have to vote on before that person was hired, or would we just delegate that authority?
This is my suggestion. First, the only thing we're really talking about here is hiring an investigator. Once that person is hired, then none of us are going to have day-to-day interaction. We're going to give that person a job, and he or she's going to go do it. So it's not like I or the chair or Mr. Lempe are going to be telling this person what to do. I think the direction is we want a full and fair investigation. Come and tell us what you find. So the question is, how are we going to get that person hired? My suggestion is this afternoon at the board meeting, because we don't take action here at the workshop, is that there be a motion to authorize, whether it's the chair or however you want to do it, but I have no problem with authorizing the chair to do it, to work with staff, meaning Mr. Lempe and me, to hire an individual. So that wouldn't come back before the board. We would find an appropriate individual, and an appropriate individual would be someone with relevant experience, and most importantly, who has no interaction with the district. So that's how I would foresee it happening.
Okay, Caroline.
What I wanted to say is that we have to be very careful that we don't get into micromanaging.
Absolutely.
Because the only one that we're responsible to hire and fire is the superintendent. So Scott Lempe is not our employee. He's under the direction of Todd Bowden. But I don't have a problem with the two of you looking and hiring somebody. I don't think it should be the onus of the chair to do it alone, and I don't think that Scott should do it alone because of the fact that he is an employee. But the two of you together, I think, is a perfect match to do that.
And I'll add that I think one of my biggest concerns was making sure we all had the same information at the same time. Not once the investigation's complete, and if I know you want to speak to that as far as what would take place there. There are different scenarios depending on what.
Well, again, I think when an investigation's complete, it certainly will be shared with the board. It will be shared with the relevant people, including Mr. Lempe, but also anyone who's implicated. At the appropriate time under the statutes, it'll become a public record. It would then be up to the board to decide what, if anything, the answer may be nothing, the answer may be something, that the board does vis-a-vis the superintendent. It would be up to Mr. Lempe to decide what to do, if anything, vis-a-vis any other employee of the district, because those people, chain of command is not to the board, as you say, it is to ultimately the superintendent, and Mr. Lempe is functioning now as the superintendent for the limited purpose of this investigation.
Okay, did that answer your question, Caroline?
Yeah.
Okay, Shirley.
To follow up on my question, that was my concern, was that I didn't want to hold it up, or if it had to come back to the board, nor just put it on one person's shoulders. So I think that the three of you together, or Bridget with input from the two of you, hire somebody. But I do believe that that person should report to the board via the board chair. So there is that arm's length distance from that. So, I would be supportive of Bridget being involved, and that person reporting back to Bridget as is being proposed, I believe.
And then any additional information, when appropriate, being shared, again, collectively, okay. So did you have are you clear? So are there any other additional comments on that topic?
So I think we'll just, at the appropriate time in the board meeting, we just need a motion to accomplish that this afternoon at the actual board meeting.
Eric.
I'd be remiss in not bringing it up, the fact that we didn't find out about this investigation till the person sent it to us. So I'd like to ask on the record, have there been other complaints during this course this year?
Not anything that I'm aware of that has any anything to do with this, whether there's some complaint about something completely different, I don't know, but nothing involving the superintendent of which I'm
There's been no complaints involving the super. I just want to make sure that's on the record.
And if I may, real quickly, and I would say that in any event, there may be learning experiences that will prompt us to take action on whether it be policy and to respond to some of the concerns, which was one of my concerns as well. So go ahead.
I remember a few months ago we had directed staff to come back to us with a policy, and I think even in view of things now that we ought to look at a policy, and perhaps on that policy that we are notified via phone call or whatever, because I know we're talking about records that are not public records when they're filed, any complaints against the superintendent, or I would like to see any complaints of sexual harassment against our employees.
And any
at least administrative up, yeah.
So as you'll recall, we're in the midst of reviewing all of the board's policies today. Interestingly enough, we're in Chapter 6, which is where I think this policy lives today. And there have been a couple of occasions where we have pulled policies to the front of that list, 7.71 being most recent. If you would like us to pull the discrimination and sexual harassment complaint policy to the front of that list, we could be prepared to come back to you as early as your January work session and talk about what you've seen in the past. I think you've seen things as far as March of this year, and then in August of this year, we could bring that back and have a discussion about where that policy needs to go.
And that was what I was initially going to propose, because I know there's been a lot of front-end work on it, and that hasn't moved forward. So, and I think time-sensitive wise also would make a lot of sense. So I agree.
Okay.
Again, I would remind us that any complaint against the superintendent should be brought to the board's attention. Any complaint against an employee goes to the superintendent because he is their direct supervisor. We are not. So remember that.
Well, I remember it.
Caution again before we go into that discussion. I don't want to specifically.
Well, and I think that's a legitimate conversation when we're looking generally at the policy. Mm-hmm. And we've had some, I think it was back in February, some conversation with some language proposed that we can bring back, as Mr. Lempe says, at the January work session to talk generally about the policy. And
then given past experiences, if that policy would not address certain items that we are feeling that may be existing currently, we address those at that policy discussion from a conceptual standpoint. So, Jane.
I agree. I think we can go down the rabbit hole very quickly with this, and we do have one employee, and it is the superintendent, so we need to look at this carefully.
Very good. So that, I believe, is the first part of the complaint investigation process, and Mr. Hardy, if you can lead us down to the second topic.
Sure. As the board is aware, the superintendent made a request of the board chair that the board, pursuant to his employment contract, authorize him to employ a lawyer at the board's expense to assist him in responding as part of this complaint process. I gave the board some information by memo yesterday regarding both his request and the specifics of his contract, and it is up to the board to make a determination if this is the type of circumstance that's covered by his contract, and if so, whether the board determines that the superintendent should engage separate counsel, which is language specifically from his contract. I believe that is in the board's discretion. That would also obviously take action if that is what the board chooses to do at the board meeting later today, but this is the time, if the board wants to have a conversation about that, this would be an appropriate time to do that.
Is there any discussion? Eric?
First, a question. Would this fall under civil demands, criminal proceedings, claims, suits, actions, legal proceedings? Which ones of those that's defined would this internal complaint process fall under?
Internal complaint process or equity complaint is not specifically one of the types of things that are listed. It depends on, I suppose, how broadly the board would want to read some of those words.
And I'm more inclined to try and read it broadly, but then the next question is does Dr. Shelley, who's the actual named person, will we be paying for an attorney for that individual?
I think historically we have never taken the position that when we were investigating an equity complaint that we provided counsel for any of the people who were targets. Of course, they don't have a separate contract like the superintendent does, but we have not done that historically.
We would have to negotiate. We would have to interpret this pretty broadly in order to give this to him.
That is in the board's discretion.
It is within our board discretion, but then the question is, am I going to have teachers coming up here, custodians saying, you gave it to the superintendent, why won't you interpret it, why won't you provide these things for me? Rachel, what could I say to Dr. Shelley if she comes up tonight and says, are you going to give me an attorney? I don't know, and I think I'm a Rachel Shelley fan, I'm a Dr. Bowden fan, but how would I say yes to this person and no to that person?
I think that is something for the board to consider.
I mean,
well, I mean, it's up to the board to decide if it wants to do that. I would suggest if the board chose to read this broadly and did that, how you would respond to someone else would be one of two ways. One saying the superintendent is different because he has a contract that says that. The other way you could respond to it is provide everybody an attorney. I don't believe that would be in the board's best interest to do that latter, but that is the board's choice.
No, and I think that, again, broadly speaking, and I think that you raise a valid point of whether or not, how do we interpret the current contract and what precedent that would set in general, no matter what the circumstances of the complaint is. Shirley, did you have a question or a statement? Oh, and then, yeah.
Go ahead.
Jane.
Well, I think, again, we have one employee. It is the superintendent, and his contract does call for this in that case, and I interpret that from looking at your questions as yes, we should provide him with an attorney. As far as an administrator goes, I think they have a contract, and something could be provided or changed in their contract that would, in effect, require us to, or require the superintendent to look at legal issues. But if that's not the case at this time, that's not the case. So and again, we only have one employee. So I think I'm looking at this narrowly and saying that yes, we should provide Dr. Bowden with an attorney.
Shirley?
To say the initial complaint, there really wasn't an initial complaint. There was an initial investigation, and then an untimely complaint was filed after that. But the initial complaint on this person, how was that resolved?
Can I take a pause, though, really quickly? Because I want to make sure, and I think, I don't know for clarification purposes if that's more appropriate on a conversation with Mr. Hardy and Shirley, but I think that the question today, right now, is our current contract, as with the circumstances we are just previously discussed, is does the contract language trigger authorization for an attorney for the superintendent?
That is the question the board will have to answer in order to respond to the superintendent's request.
Okay. Did that, so based on the contract that was signed and approved, I want the board to know that was requested, and again, the action would have to take place at the board meeting this afternoon, but from a discussion standpoint, I wanted to provide it now.
Well, part of my question was, I believe the initial complaint was unfounded on this person. There was inconclusive on another. Yeah, well, we don't know.
I don't recall all the nuance of it. Certainly, there was nothing. There were certain allegations that were considered unfounded, certain allegations that were considered inconclusive. But be that as it may, the circumstances have changed to the extent that we now have a contract that we have a request under the contract that we need to respond to. regardless of what happened with respect to the underlying complaint.
Yeah, well, it does say claims. I'm not sure what claims, and actions. So actions is in itself broad, and if we think that word is too broad, then I think what we need to do in the next contract is narrow it. I'm frustrated that we as a board would have to do this, but I'm also frustrated that so would the superintendent. But
So from a legal standpoint, as it relates to the contract language, so the interpretation, in the event the action of the board was to deny this request, what exposure would we have then at that point?
Theoretically, the superintendent could say you are breaching his contract by not doing this.
Okay.
I think that there is a two-step process really here called for by the contract. The contract says the board will defend, hold harmless, and indemnify the superintendent against all, and now we have a list of types of things: civil demands, criminal proceedings, claims, suits, actions, and legal proceedings brought against the superintendent individually or in his capacity as agent or employee of the board that arise from his duties, in the course and scope of his duties. So there is not, if it specifically said equity complaint, I would tell you, you know, that box is checked. I think, frankly, an argument in this circumstance, and it probably wasn't contemplated by me as one of the drafters of this, that this circumstance would come up, an equity complaint. I think you could read these to be more restrictive than that, to say these are claims for damages, which an equity complaint is not, at least at this step. Or you could read it more broadly and say this is, in essence, a claim or an action. Action, to me, usually refers to something filed in a lawsuit, but it could certainly be considered a claim if you want to read it broadly. The second issue then becomes, if in any matter covered by paragraph A, which is what we were talking about, so if the answer to the first question is yes, then the board determines the superintendent should engage separate legal counsel. So that's where I believe, even if it was clearly one of those things, the board would have discretion under this contract, which is why the first issue is important but not dispositive, because under B, and this was written with the ability, obviously in a bit of a vacuum, but written with the ability to give the board as much discretion as possible, which is what I try to do on your behalf in contracts. So then you have to exercise your discretion to determine if the superintendent should engage separate counsel at the expense of the board. Obviously, any employee can always have counsel at their own expense. The question is whether you're paying for it. So there, it is a two-step process, and that's the decision the board needs to make. And that's why I'm trying to outline the issue for you without, I think the board does have discretion without telling you you should do A or B, because I think it's in the board's discretion. It's not clear-cut under the contract. You must do this or you may not do that.
Thank you. Caroline.
Again, I would reiterate that he is our employee and we have a signed contract with him and we should follow the contract. I believe we should provide him with the legal services that he's asking for. And as far as providing legal services to anyone else, that would be the superintendent's call, not our call.
Okay.
I gotta really keep it clear what level is here and what level is
Which lane? Go ahead, Shirley.
I agree. It says all, you know, and take everything else out, but claims or actions. And, you know, if we wanted to make it clearer that this wouldn't have been covered, we should have done it at the time we made the contract. To say that we wouldn't have anticipated anything like this, yeah, really? It says all claims and actions if you take out any of the other words. And so this is covered. You know, I don't think there's anyone here less wanting to have to hire an attorney than Dr. Bowden in this. I mean, but it's come back again, and he is now our superintendent, and I think now we have to follow the contract.
Eric.
So if I think the majority of the board are saying that it falls under one of these criteria, so then the finish of the sentence, it says brought against the superintendent. Do you believe that the complaint that we have now, if we read in such a way that the complaint is one of these lists, do you believe that the action was brought against the superintendent?
Well, I believe if the board is taking the position that it should hire the investigator as opposed to run through the equity policy, that I don't believe it is immediately brought against the superintendent. It's brought against the immediate supervisor, but I think the board reasonably is saying that the actions of the superintendent are implicated. So again, it's not specifically, no, I don't think that it is specifically against the superintendent, but I think it's reasonable to suggest that the superintendent is implicated, which is the basis of hiring the outside investigator.
And since I don't have that much knowledge about how equity complaints work, I saw this list as things that could result in the superintendent either losing property or freedom, criminal or civil. So if, hypothetically speaking, we lose on all counts, that the person is totally right and knows retaliation, worst case scenario, what would be the damage to the superintendent?
Well, and I want to say that by investigating a complaint, there isn't winning and losing from the district's perspective. Okay. There is investigating a complaint, which we are obliged to do for lots of reasons.
That person prevailed.
Right, but if the decision is made that there was, in any context in an equity complaint, that the complaint is founded.
Okay.
That in and of itself does not translate into a judgment against either the school board or the individual against whom it is complained about. That certainly could be the basis for the board to take remedial action, to do something for that. If the person, for example, had been denied a raise or denied improvement in their job or had been fired, the board could take action on that. But the result of an equity process is not like a lawsuit where now there's a judgment for X dollars.
And if we were going to...
that could happen later, but not as a result of this. If we're going to agree to give an attorney,
would it be proper to do a not to exceed amount, or would that be restricting his ability to get an attorney, or would you not put that in there and allow him to get his...
I think if you're going to hire an attorney, you cannot be in the position of, you're just paying for the person. You're not really hiring them.
Right. But so if we say, yes, we think you should get an attorney, and yes, we're going to pay... Because I remember when Susan Chapman, there was always these thresholds. They said, we'll agree up to this amount. I mean, could we say, up to $100,000 or up to $20,000?
I suppose you could do that with the caveat that you would need to come back and get further authorization, but you certainly can't direct that relationship.
No, I wasn't implying that.
Right.
Is it normal to put a dollar limit? If you go above that, you have to come back? Or is
I honestly can't recall a situation where the board has hired a lawyer, I'm trying to think, but a lawyer for an employee. Typically, in cases we deal with, when employees are sued, and it doesn't happen often, I'm able to quickly get them out because they're tort-type claims and they shouldn't be sued in the first place. So I can't tell you there's certainly no typical for us, and I would have to investigate further what other...
So we've never paid for an attorney for an employee?
I hate to use the word never. I cannot recall such an event other than me representing the board or someone else. It's always the board who sued. I mean, this would typically come up in a civil rights kind of context.
You've answered.
All right.
So I just need one point of clarification, and then based on the discussion, we don't need no action today, right here, I'm sorry, at this moment, but upon the decision of the board members, there will have to be an action taken this afternoon. So what I wanted clarification is, as it relates to the investigation process, that it... in past circumstances, no matter what, any kind of equity complaint and investigation, is legal counsel ever present or often present for any individual who may be part of the complaint?
I am typically not involved in the equity process. If you had one employee claiming some type of discrimination or harassment by another employee, those are typically done through our policy, which would be the cost center head or his or her boss moving up to the equity coordinator. So I'm not directly involved in those.
Okay.
I am not aware, maybe Mr. Limpy has better information than I do, I'm not aware. Certainly, the board hasn't supplied those lawyers. Whether an individual has a lawyer on his or her own, they certainly would be entitled to.
And that's what I guess if we just spoke in general on any other, and the board, maybe take the board having expense or paying for that, is there often counsel representing any individual in these investigations? Because I understand them as a very interview process to gather facts. That's what.
I don't know that I'd use the phrase often, but it's not unheard of that somebody in the process would have, as is the case, frankly, with grievances and other things that happen like that, where an employee may bring outside counsel, but not at the expense of the board.
Well, in a grievance situation, I mean, most likely an employee is going to be represented by the union. Mm-hmm. Not always, sometimes. And sometimes they have others who, I won't even use the word represent, but join them. Sometimes it's family members.
Right.
But it could be a lawyer.
Okay.
And has been.
Okay, thank you. Did you have another comment, question?
Yeah, what is this attorney going to do? I mean, is he going to sit in on all of the investigations? Or will he get reports from the investigations? Will he be able to question at these investigations?
No. If a witness has an attorney, the attorney can join the witness when the witness is being questioned. This is not a separate our investigator, the board's investigator, assuming sounds like that's what's happening, is going to interview whomever he or she thinks is relevant, get whatever documents he or she thinks is relevant, and a lawyer for the superintendent or anybody else would be there, be able to counsel the witness beforehand, during, but this would not be someone who gets inside information from the investigator or would follow the investigator around. It would just be someone who was with the witness at the time and provide whatever counsel would be appropriate.
Okay. Do you have another question?
Yeah, I mean, I know that we're hiring a separate investigator, saying that, yeah, this probably does implicate the superintendent. But isn't this case whether or not she was fired for grounds or fired for...
Again.
Not fired.
Again.
I'm sorry. Not
stop.
fired.
Please, hold on.
The case, it's not...
Shirley, hold on.
I don't even know what it all is. I haven't seen it.
I understand that. So if that comes down to, again, the question is, there is a complaint. I think in the previous discussion we have agreed, and dependent upon what actions taken this afternoon by the board, that there are implications of such that include the superintendent and us as his supervisors as it relates to are going to be part of this process. Next step is, regardless of anything else, is the superintendent, per his contract, has requested that we authorize legal counsel at the board's expense. Does the contract language fall under that or not? I would very much caution that we don't opine on any of the topics of the investigation.
I'm not even quite sure what but it has to do with Dr. Shelley's actions, and I'm not even sure what they are versus what she has said they are.
So again, I think the question before us is, does our contract authorize legal counsel to the superintendent upon a request, period? I would say as narrow as that for everyone's sake.
All right. Okay.
And then if there's any further discussion or an action must be taken, because there is a request that happened this afternoon, but from a discussion purpose, I wanted to make sure that we were able to have it addressed today, this afternoon, are we this afternoon? We're this afternoon now. So, but to get into the discussion of the investigation, I we cannot go.
Well, and I would echo the chair to say, you're hiring an investigator. You're not supposed to know all the details. There's no way for you to know all the details at this point. That's what the investigator is supposed to ferret out and present you with a report, which then you will have to decide what you're going to do about it, if anything. As it respects the superintendent, Mr. Lempe has to make those same determinations as it respects any other employee.
Okay. So unless there's any additional legal questions for now, again, I'd reiterate that based on the discussion here, I think that the action before us on this topic for council is the interpretation of the board members as whether or not the contract that we adopted and signed with our superintendent triggers council in this current circumstance, and that can be taken at new business this afternoon.
And right, to put a bow on this whole discussion, I think at the conclusion, or just before the conclusion of your regular board meeting this afternoon, the board needs to consider taking two actions. The first one is to authorize, and it sounds like from the discussion, people are on board to do this, to authorize the board chair to work with myself and Mr. Lempe to hire an outside investigator to investigate this. And then the second issue, which is the last one we've been discussing, is to consider whether the board wants to authorize the employment of counsel at its expense on behalf of the superintendent. And you can choose to do that or not do that, but that request has been made, and so that should be taken up by the board. And the board, I would just remind the board chair that before any of that occurs, we would need to let the public comment on it, since this wasn't specifically on the afternoon agenda, but I think it's all time-sensitive matter that can be added.
Understood. So if we are good on that, is there any more comment or discussion? We're going to take a 5-minute recess as we conclude on that topic, and Dr. Bowden will be joining us to reconvene. So 5 minutes, please. Welcome back to the monthly workshop agenda. Before we move forward, I know there was one addition, and while we have Mr. Hardy here, so solicitation of contributions. Dr. Bowden?
Yes, on December 8th, there was an email from one of your members, Shirley Brown, to Art, specific to legal requirements around solicitation for school millage referendum. So since Art was going to be here this afternoon, I asked that he remain and add any comments that he may wish to add to this email and take any questions that you may have of him. So at this point, Mr. Hardy, the floor is yours. Do you have anything to add to the content of this email?
Yes, just briefly, Mrs. Brown provided me with an email from December 8th from an attorney at the Commission on Ethics who gave her interpretation of Statute 1001.421, which involves prohibition on school board members receiving gifts in excess of $50. And the specific context of this request comes down to, may a school board member solicit contributions to an outside entity, such as, for the referendum, CBS, Citizens for Better Schools, although it's certainly in no way limited to that context. I think it could also be an outside entity, perhaps like the Education Foundation or any other outside entity. And the attorney from the Commission on Ethics went through some previous ethics opinions that said for non-school board members, such solicitations were legal because the statutes on solicitation of gifts generally had a caveat that if the individual was not receiving any benefit themselves, they could do it. But because there was a separate statute on solicitation of gifts for school board members that did not cover that circumstance, or that did not have that same exception to it, it was her opinion that school board members should refrain from engaging in such solicitations from any person, vendor, potential vendor, or any entity doing business with the school board. So that was her opinion, and that's coming from the Commission on Ethics, and it is not an outrageous interpretation, certainly. It is an interpretation of the statute. She recognizes that the Commission, although this is an ethics type of issue, the Commission on Ethics does not have jurisdiction over the school code, so it would not be the Commission on Ethics who would be dealing with this issue if a complaint was brought. I know we're getting a little bit into the weeds, and it's hard, but I want to tell you I believe there's another interpretation to this that is also certainly very plausible, and it's based on the statute itself that relates specifically to school board members, which again is 1001.421. It says, and I'm going to read it in its entirety because it's not very long, notwithstanding any other provision of law to the contrary, district school board members and their relatives, as defined in Section 112.312.21, may not directly or indirectly solicit any gift or directly or indirectly accept any gift in excess of $50 from any person, vendor, potential vendor, or other entity doing business with the school district. The term gift has the same meaning as in 112.312.12. So clearly, the attorney who gave Ms. Brown her email, her opinion, is right that there is no exception within that like there is in the general ethics statutes that say, but this doesn't apply if you don't get, and I'm paraphrasing, if you don't get personal benefit. There is no such exemption. But I think what's important is the statute, the school statute specifically says the term gift has the same meaning as elsewhere in the statutes in .112.312. And in that statute, it says gift for purposes of ethics in government and financial disclosure required by law means that which is accepted by a donee or by another person, or by another on the donee's behalf, or that which is paid or given to another on behalf of a donee, directly, indirectly, or in trust for the donee's benefit or by any other means for which you don't pay. So the question is, if, for example, a board member were to say, I would appreciate it or I would encourage you to give a donation to CBS or the education or anybody else, a nonprofit helping the school board, whether that is a gift under the statute. I have not found, there is no case law interpreting the school board statute. And again, gift is that which is accepted by a donee, all right, so that's if you got it, or by another on the donee's behalf. Well, in my scenario, someone is writing a check to CBS. Is that being given to CBS on your behalf? That's the question. I think there's certainly an argument that that is not happening. Usually when something's done on someone's behalf, it's done to help that person. I'm paying, tuition for my child on my child's behalf at college, or a debt is being paid or something. I have found no law, again, interpreting that. That circumstance was not discussed by the attorney from the Commission on Ethics. I don't know where she would come out on that. Maybe she considered it and didn't even think that was an argument. I don't know. But that's the issue. So I guess where I'm leaving you is we've got this opinion, which is not a binding opinion in any way, but I certainly would never tell you to disregard something that comes from an attorney on the Commission on Ethics saying you shouldn't do this. I believe there is another plausible reading of this statute. What you do with all that information, I know I'm just dumping this out on you and saying there's an argument either way here. I suppose the only way, or a way, to get this resolved, one way is to do it and somebody files a complaint and we deal with it. That's never a good way to get it resolved. We could request an Attorney General opinion if the Attorney General would opine on this. Of course, don't ask the question until you're prepared to deal with the answer. I also don't know that it would be timely, frankly, to get it back in time for it to matter for, at least for purposes of the March 20th referendum. But I was asked to comment. I just got this and I was asked to comment on it, and those are my comments, and I will take any further action the board would like me to.
I have a quick question. When you're saying when one person goes and asks or suggests, or whatever the word may be, seeks a contribution, donation to any entity. So my question was, the implication would be to that individual person who's requesting that versus the collective board from an exposure of which was interesting here, is that the Commission on Ethics would not. That would not be considered under them, but it would be more of a civil or legal complaint.
Well, right, because the Commission on Ethics has jurisdiction over the Ethics Code.
Correct.
And the Ethics Code would allow this type of solicitation. If you were a city commissioner and were making this type of solicitation, the Commission on Ethics has already opined on that and said that's okay because it's not for your personal benefit or the benefit of your relative. It's for, in essence, the greater good. What the attorney is pointing out correctly is that there is a separate prohibition against school board members receiving gifts outside of the Ethics Code,
right,
which is part of the Education Code, which the Ethics Commission has no jurisdiction over. If someone said you, a school board member, was violating 1001.421, the Ethics Commission would say that's not under our jurisdiction. We can't deal with that.
And so then would the implication, again, be something that would expose the board as a collective whole or the individual?
I think it's I'm aware of no law under this specific provision. I think it would be something that would go against the individual because the prohibition is against an individual.
Okay, thank you.
It's specifically school board members and their relatives may not solicit gifts.
Eric.
So because today is Tuesday and the day it ends in Y, in my office today, there will be an envelope, and that envelope is going to be full of checks. Those checks are going to be for PACs. So if one of those checks is from a vendor of the school board, bottom line, am I going to get in trouble?
I would think not, but all I can tell you is what the lawyer wrote, and that's been shared with you, I believe, what the lawyer has written from the Commission on Ethics that talks about this is a much stricter or a stricter statute with regard to school board members, and she concludes by saying, thus, no similar charitable solicitation exception could be derived from the more specific language of 1001.421. Therefore, in the absence of such an exception, school board members should refrain from engaging in such solicitations from any person, vendor, potential vendor, or other entity doing business with the school district. Now, she's taking a broad reading of that, and I can't tell you that that's wrong. I think it's plausible. I think there's another explanation or another interpretation which would say it is not a gift in this circumstance as gift is defined. And I read that, I won't go through it again, but I don't think it's on your behalf, if you're giving to CBS or the Education Foundation, it's not on you. It's certainly not accepted by you, and I don't believe it's accepted by them on your behalf.
So there's an argument that I'm fine.
There's at least an argument.
Then I'm fine. I can argue.
Caroline.
I do not see a problem. We do not touch the money. We do not touch the check. All we ever do is to talk to our vendors and people that we know and say, the referendum is coming up. Do you have any interest in helping us? Or something to those effects. And sometimes the actual vendors come to us and say, I know that the referendum is coming up. Who do I make a check out to? Who do I send it to? I mean, we certainly do not benefit from it in any way at all. So I do not see that being a problem.
Well, and that's why I would argue it is not a gift under the statute.
Not a gift.
But all I can do is tell you that there's at least this email floats, it doesn't rise to the level of an opinion, but this email floating out around there that could could lead to a contrary result. So I've been asked to make you aware of it, and that's the best I can do, short of asking for some kind of opinion to get this resolved.
Shirley.
The reason I brought that up is because ethics laws can get tricky, and under the ethics law there is that right that it has to benefit the reporting individual, and there's an exception for your own campaigns, which I can't accept $100 from them, but I can accept $1,000 for my campaign. Sometimes you wonder, but that there isn't that carve out for your personal gain in the school board issues. Now, you look at that and you say, well, your vendor could feel that, well, if I don't contribute this money, well, maybe will I not get the contract? And I know that we aren't involved in giving those contracts out except to approve them at the end. We do have, I think, a fair process that it goes through. But I know and I wasn't thinking of other PACs or anything else. I was more concerned about the referendum. And whereas there was that carve out for the regular ethics, there wasn't one for the school board. And I think, yes, there could be an argument if, in fact, it was brought against us or a member that it should be the same as it is under the other. But I just think that if it does get brought up, that it might be an issue for one of us individually.
I did look to see if I could get any clarity on what was intended when the specific gift prohibition law was passed against school boards, and that was not very helpful. Frankly, it was part, here's something that'll shock everyone. It was part of a bill that had lots of provisions in it about education, and I don't believe she had the opportunity, but I didn't look. This was 2011. In 2011, and there's the final bill analysis, which I pulled from the House website, and it has a number of things listed about voluntary pre-K, assessments, grades, programs, and then miscellaneous, and it is one of miscellaneous that just says it revises the gift ban law for school board members, and the entirety of effect of bill section is the bill prohibits school board members and their relatives. It basically just regurgitates the statute. It doesn't really say what it's intended to cover. My guess is there wasn't really a thought about this particular issue. I think the primary thing was saying school board members are limited to $50 as opposed to a higher limit. But one can't tell that from the analysis. So I'm merely making you all aware of this, telling you there is a contrary interpretation that I think is at least as plausible, and seeing if you want me to do anything about it.
Did you have any comment? Jane, go ahead.
Well, not to beat around the bush, but I'm the person on the board that has more to do with CBS than anybody else, and I will tell you that I am staying away from any direct ask of anyone for the referendum, because there's been some conjecture in the community of people circling around and calling people that I've had lunch with and asking them if I'm bribing them and so forth, and that certainly is not the case. And I would say that I'm just going to be even more careful. Now, I know that Eric and Bridget are involved with some money raised in PACs for the referendum as well. I can't address that.
Clarify. No, that is not.
Okay,
is not
well, that's
accurate.
what I've been told. But at any rate, I will tell you this. Mike Pender is the treasurer of CBS. CBS is a committee in existence since 2001. There's nothing and no way that I would ever misconstrue or misrepresent the school board or CBS. I am trying desperately to raise some money and to in just general talk, if you will, and raise interest in people getting out the vote for the referendum, because I think it's so important to our school district and to our students. So we can't have more people involved with that committee because of sunshine laws, or else we'd all be on it, I'm sure. But I just want to say that I am careful. I am concerned. I know there's an issue between candidates and issue oriented requests and work, and I am very aware of those issues. But I am certainly making sure that I stay away from anything that would be considered by any to be inappropriate.
Are we done with that topic? Okay.
Thank you.
So thank you very much, Mr. Hardy. You were very helpful today. Next up, unless there's been any other change, Project 10 and graduation rates, Dr. Kingsley.
And I'm just going to quickly introduce the committee to you. I will tell you our topic this month. We have 2 presentations for you, and they are all about celebrating learning. So this is a team that is celebrating learning with some of our most at-risk students, and we have Dr. Dawn Clayton, Steve Cantise, and Millie Wheeler, and they have been working very hard on a project called Project 10, and Dawn, I know, is going to thank a couple of other people who've worked on it.
And I just want to chime in because I know we talked about this in the break, Dr. Kingsley, but in the event we run out of time because there was an unanticipated discussion topic, I don't want you to rush through anything, so if we need to add it to January, since you guys worked hard, thank you.
Okay, good afternoon, school board members and superintendent. Thank you for having us here today. It's my pleasure to be here to introduce you to a process that we use in our schools. It's certainly a data-driven process to track every student in this district, every high school student in this district towards graduation and to get them across the finish line. I think you'll see through the data that we share today that over the past several years, we've made some great progress in the area of graduation rate. And you think about the numbers, you think about the data. We always say the data represents students. It's not about school grades. It's not about percentages. It's about getting students across the stage, the most important thing we do. So without further ado, we'll go ahead and get started. Just to kind of walk you through this to my right, I have Millie Willer. She's our program specialist and judicial liaison. Does great work in our area of dropout prevention and with some of our most at-risk students. I have Dr. Dawn Clayton to my left here. She's our supervisor of alternative education dropout prevention. As a team, they're both new to their positions here, but wow, they are really good at what they do. So I'm excited to have them part of the work that we do. Great hires, and certainly this is right in their wheelhouse. They're doing incredible work. The agenda for today, just quickly, I'm going to give you an overview of the Project 10 process and where it came from. Dr. Clayton's going to talk a little bit about the data folders that have been created for every school that tracks every student in their school towards graduation and the process they use to track those students. And Ms. Willer's going to talk about, because she came from a high school last year, Booker High School as a guidance counselor, she's going to talk a little bit about what the process looks like at each of our high schools. So as an overview, Project 10 has been in place the last 4 years. It started as a project out of USF for students with special needs, trying to help them towards graduation. When we saw the process and we saw the impact it was having, we felt like it would be incredibly positive for all students. But the question became, could we integrate all of our needed departments to make sure that we could pull the data and put the data together for this project? So we had to scale it up. To scale it up, we needed to bring the PSS department under Sonia Figueredo-Alberts, Dr. Cantalupo back here in research and assessment. Everybody knows her well. Pull the data in. Rodney Davidson with the data analysis and reporting. Catherine Kokoza in our curriculum and instruction, and others in curriculum instruction. Also, of course, our alternative ed, dropout prevention, and judicial liaison. And as a group, the process was developed, and I have to give huge credit, take a step back to when Bethany King, I think most of you know Bethany, she was our dropout prevention coordinator and wore many hats, but this was under her leadership that we were able to push this through, working with Rodney and Denise to get the data pieces together. It's been very effective. School level teams, at every school we have a team. Those teams include assistant principals over administration, guidance counselors, registrars, our APEX, our PBD specialists at each school, ESE and ESOL liaisons, and other people at each school that each school determines needs to be there. Also, Dr. Clayton, Ms. Willer meet with each school every month to monitor the process. Understanding that school graduation rate is a part of our school grade. The high school comprehensive school grade is 1,000 points for a comprehensive high school. The graduation rate accounts for 1/10 of that, or 100 points of that school grade. So we'll show you the data and what we are projecting our data for this year to be. We understand that the data was closed or is closing on December 15th. That has to be to the state from last year, and we would anticipate, we hope to have the graduation rate back in before the holiday break. Also, understand that in the school grade, it's lag data, it's 1 year lag data. So in other words, the data is from the previous year because it takes them a while, as you can see, through December to get this data together. So I'm going to turn it over to the two specialists here, and they'll talk a little bit about the data and the process.
Well, good afternoon. It's a pleasure to talk to you today about graduation, what Project 10 is about, and can you hear me? Okay, great. What Project 10 about is collective efficacy. It's about ensuring that everybody across our district and our schools, and even in some cases organizations beyond our schools, are working to ensure that our kids are getting across that stage, helping our children to overcome whatever obstacles or barriers are in front of them, or just giving them the extra nudge to get over the hurdle. So with Project 10, what we've decided to do is to organize our efforts using some technology. So the graphic that you see in front of you on the screen, those of you who see the screen or you have a copy of the PowerPoint, it emphasizes the 3 prongs of Project 10 that make it so successful. Steve talked very well about what happens at the school and at the district level. We'll give you some more information about what that looks like at the school level and how we support our schools with monitoring support to the children. But I want to talk to you, too, about 2 other pieces of Project 10. The first piece is the data monitoring piece and what that looks like. I'll give you a glimpse into the world of what we do with some technology, which is really exciting, we introduced this year, and also what those community-based supports looks like. You know, we know in Sarasota County we have some of the best practices across the state, and I venture to say even beyond the state, in terms of community partnerships. So we want to talk to you just briefly about how that looks in the world of Project 10 and monitoring students to graduation success. So I want to say thank you also to Brandon, who's helping us out today. So he's going to show you, if you could just turn your attention, because you don't have copies of this, to an electronic resource in Microsoft Word, so one of the screens, and it's called OneNote. And I'd like for you, Brandon, to first turn to the data page, because what I wanted to do was to highlight some data here. And Brandon, if you can just make that screen a little larger, maybe at 150%, just to kind of show that a little bit more to the committee that's here. OneNote, just to kind of give you an overview, is a way to organize all of our ideas and all of our communication on a particular topic. In this case, we're talking about graduation success rate for children. And all of our school-based teams, district support teams, pupil support teams have access to this notebook. And in this notebook,
Which one are we looking at? Northport. Is that Northport?
yeah, it's Northport. Okay, so and in this notebook, we have several tabs, and when Brandon is able to kind of zoom out a little bit, I'll show you what those tabs look like. And one of the tabs, it's...
I just want to point out our communications director is cross-trained in IT.
Yeah, he's cross-trained in IT, and thank you for that, Joe, and thank you for that, Brandon. So what you're looking at right now is part of the Project 10 database that our schools have access to. You're looking at Northport High School and what their graduation rate looks like. So we have a system of color coding, and what color coding does for us is let us know where all of our children are at in terms of their graduation. Have they dropped out, which we won't want to see? Are they on track for graduation? Or are they in that category of at risk, which is the yellow target, and then orange, which is the extremely at risk? Anything below the orange line, our children have dropped out.
What are the 2 numbers in each group?
Get into that. So what you see here are actually predictions for the current cohort of students in Northport High School who are 12th graders on track to graduation or just where they're at in their status. So if you can just scroll down a little bit, Brandon, what I wanted to focus your attention on are 2 things. That's perfect. Are 2 things. So first I wanted to focus on you, some of the success that's happened at Northport High School. If you look on the left-hand side of the screen toward the bottom, 2016-17 school year, the predicted graduation rate for Northport High School current cohort is 85%. SWD are our children with disabilities, not just us, all of our students with disabilities. The rate is at 70%. And I wanted to point out Northport High School to you as an example. All of our high schools are making great growth in this area, because if you look at the line above that, you see that there's been amazing growth, specifically in the area of our students with disabilities. So this is exciting to look at this. And then if you look at the diamond over to the right-hand side of the screen, you can see that there is a projection based on the progress and the monitoring that we've done already for the current cohort of seniors. And that projection is at 87% overall, which is a total increase of 2%.
I have a quick question. So I see the increase in graduation rate, and this is always a discussion, and then we have the dropout rate also increasing at the same time. So, and I know that they're calculated differently as well. which is convoluted at best, if I can say that personally, is my opinion. But so if I'm looking at this, it's exciting to see that the graduation rates are in fact improving, but yet the concern, I would immediately say that, but our dropout rate is also increasing.
Right, and I'll let Millie speak to that because the two are very different. Mm-hmm.
Right, so that is a concern, and it's a little bit different for each school. This just happens to be this one, but there are different components to so there are graduates, non-graduates, and dropouts. The dropouts, I will tell you, they are very specific groups of students that have either just refused their educational services at a certain age, they had just stopped attending and we weren't able to locate them or pull them back, or they're students who said they were going to sign out to go get a GED and then never enrolled in a GED or successfully completed a GED program. We do know that that is an area of concern. It's certainly something that we are looking at, and as we are new in this area, it's an initiative that we have taken. That line item is new to Project 10. It was just added this year, something that we are working with on each individual school team. That's part of my monthly check-ins, which I'll get to, that I am going through the dropouts in real time with the schools at their teams to talk about student by student, how did this student end up on this list and what can we do to possibly pull them back?
Mm-hmm. Good, thank you. So, and then, I'm sorry, Jane and then Eric.
Of course, the graduation rate, is this graduation rate taking the normal characteristics of a graduation rate, that percentage into effect? So we don't count dropouts. We only count students that graduate in 4 years, that come in freshmen, graduate in 4 years. So if they graduate early, if they come in as a transfer, if they drop out, we don't count any of those. Why are our graduation rates, Steve, a bit lower? Maybe one of you could address this. Why our graduation rates seem to be lower than some other counties? I mean, here we are in a district. We have a lot of great things going for us. And I look at Orange County, for example, and their graduation rates are 90% or higher. Why is that?
Well, I would say that sometimes you look at, I think there's a number of things in the collection of the data and the way it's reported, and that, I think that's part of it. I think the bigger issue is, as we've we went through some budget cuts in Sarasota County, and I don't want to use this as an excuse, but the reality is a lot of those, you'll see those counties, they have dropout coordinators in all their at-risk schools, literacy coach and those kind of things. So we talk about this a lot. The expectation is that our schools, if it's an assistant principal, guidance counselor, and we try to form those teams at the school that in some districts may not. They may have people dedicated to that. But I think you'll see that, in our, also in Sarasota County, the gains that we've made over the last several years have been really strong gains. And our goal is to get to that 90%. That's our target for this year. That's a goal that we set at the end of last year. And we're on track to make progress towards that goal. I don't know if we'll hit the 90, but I think we're on track to make progress towards it.
And are we really looking for these kids? Are we doing anything with truancy? I think truancy has been something that slipped in the last few years. Yeah. And are we really looking for these kids? I know you're talking about looking at a new program next year, because I met a young man at FSBA who's part of that from Chicago. Correct. And I think he owes me, and I think we had a bet on the coach leaving FSU, and he owes me a steak
told
dinner.
Me about that. He texted me after he talked.
Yeah, but I just wondered, are we doing more with truancy? Because truancy is a big deal.
Well, we have teams that address it at every school. Again, that comes down, how are you dealing with that? And we have truancy specialists in our district that go out and try to find these students and try to bring them back. But the real work's done at the school site, where counselors and administrators, everybody's making those calls. Every student who is at risk for whatever reason it might be are getting additional supports. And Millie's going to talk a little bit about that here in just a few minutes, and she'll have an opportunity to talk about
real quick
a specific.
Well, I was going to say, and Eric, I know Eric had a question, and Dr. Bowden. Eric.
If I may, since it directly responds to Jane's question, there are some tools that districts have employed in the area of graduation rates that we have been very conservative on their use. One is the use of a private school that will accept transfers late in their senior year because it is a private but accredited high school. It will accept all of those credits but not hold the students accountable to the state testing requirements. Every year we have students who arrive at graduation and have not passed a testing requirement. They have the right credits, they have the right GPA, but they have not passed an EOC or an FSA. And so there is a private entity in the state which, for a fee, will accept those students in and then issue the diploma. We've been very conservative. As a matter of fact, the legislature took action in the last legislative session against that practice, but there are districts who have committed literally hundreds of thousands of dollars, and it has added points to their bottom line. It is completely legal, but we have taken a very conservative approach. We have used it in some instances where foundations have done that, but we have not used any public dollars to buy a private school diploma for one of our students.
Eric.
First off, purple, great. I got it. Ms. Wheeler, picking back off what Ms. Ziegler mentioned about the dropout, is that your definition of a dropout rate, or is that the federal definition of dropout? Okay, that seemed a little bit high compared to the district. That's why I was going.
It's federal, or is that okay?
Well, the state graduation and dropout are defined very differently in different places, so it does get very confusing. Cohort drop. If you look at that data, that's based on cohort dropout. And so those are students by state definition that are part of that 4-year cohort that have dropped out within those 4 years. And then the graduation rate, it is 4-year cohort, but it does include if we get transfers in within this, they do count if they're within certain FTU windows for as long as they graduate with a standard diploma. So they are counted. Now, students that are leaving us are not, and there are certainly districts out there that are hiding kids in other creative ways as well.
My other question is,
in regards to coding.
My other question, I know that it's possible for kids to be done with school like at 8, 9 o'clock in the morning. And so I'm just curious, those kids who are done at school by 9 o'clock in the morning, do those kids graduate a higher percentage or a lower percentage than the norm? Because it seems like it's very easy to just skip school that day because it's only an hour. So I was just curious if those kids who only go to school for essentially one period, are they more likely or less likely to graduate than kids who are required to go to school at a
That's going to be a really small subset that certainly.
I know a lot of kids.
I don't think they go. One period would be some students who need that one class to graduate, but I don't think we have too many of those. We do have some part-time students.
I've taken them to a restaurant where the entire staff is high school students, and it's not right. And it's 9 o'clock in the morning. I'm like, this is the superintendent of schools, and they're all just diving on the table. Right. The entire staff, the workplace,
so the
entire restaurant.
I don't know. We don't have that. I don't know that we have that data.
Right? I mean, the entire staff was Venice. I mean, I'm not going to say what city.
I think you just did.
But I'm just curious, do those kids graduate? But you're saying just such a small, finite group?
I don't know that we have that data, to tell you the truth.
Well, the only scenario in which that would happen, and matter of fact, we're trying to make sure it never happens,